Hello, everyone. This is Leslie Seidel. I'm speaking to you from the Institute for Research on Public Policy, or IRPP as we call it, in Montreal. And I'm glad to welcome you to this webinar this afternoon, or it's morning for some of you, maybe even evening for some. We have had people participate from Europe on occasion. So this webinar is sponsored as part of the research program on Canada's Changing Federal Community, which we launched just about 2 years ago now. And under that program, we're commissioning research on a range of topics. Some of them are more or less evident given the name of the program, such as fiscal transfers, intergovernmental processes, and so on. But we also decided before we launched the program and before the change of government in 2015 that we would include some Indigenous issues. So we have published, this is our third paper, either wholly or partly on Indigenous issues. And we're looking particularly at Indigenous governance and also the relation between Indigenous governance or Indigenous communities and the federal, provincial, territorial, and municipal governments in the country. This, of course, is an evolving area. It was evolving before the change of government, but particularly with the change of government and some of the important documents that have come out, the 10 principles, the Prime Minister's recent statement. This is an area where there's obviously a lot of interest and the need for research. So we're really pleased that Janique Dubois was willing, she's written on Métis in Canada previously, but that she was willing to do an article that was published last month on the emerging policy relationship between Canada and the Métis Nation. Janique teaches in the School of Policy Studies at the University of Ottawa. So she'll now give a presentation. And once she's finished that, there'll be a question and answer period. And if you feel like sending in a question while you're listening, something comes to mind, feel free to do so. So over to you, Janique.
Great. So Anin, bonjour, tansi, Janique Nisakasun, Nimunia Sokochuan, Nehiawe Wenaskio Egwa Apitogo Sanaskio Chinia. So in addition to the introduction that Leslie gave, I wanted to add that I grew up on Cree and Métis territory in Saskatchewan. And that's where I really began to become interested in questions about Métis governance and politics. And so now I live on unceded Algonquin territory, and at the University of Ottawa, most of my research focuses on the governance practices of Indigenous and linguistic communities. But as a non-Indigenous scholar, I think it's important to remember that much of what I'm going to try to talk about today, this is my understanding of the emerging policy relationship between Canada and the Métis. And I've come to this understanding through spending time and listening and speaking with Métis leaders who I thank for sharing their knowledge with me. So when Leslie asked if I would do a webinar, I thought it was a good opportunity to continue the conversation that we started when we published this piece that you can all read online on the IRPP's website. And to help you follow along in the conversation, I've prepared a brief outline of some of the main questions that I'm going to touch on. So we're going to talk about who is the Métis Nation, what are some of the key developments in Canada-Métis relations, what is the constitutional basis for that relationship, and thinking ahead, what can we expect moving forward, and should we be optimistic about that outlook? So if we can change the slide, I'll try to help you follow along. So some of the takeaways from today's webinar, I'm hoping that you'll get a better sense of what are some of the key developments happening in Canada-Métis relations, and also understand some of the challenges moving forward. And you'll see that the main argument that I'm advancing, or the discussion that I want to have, is in part about the constitutional order that's helped us get to where we are. And so I'll be referencing the constitutional order, but to better understand the policy environment in which we are. So in order to start that conversation, a baseline of who we're talking about. If we can switch slides. So who am I talking about? Who is the Métis Nation? Well, to answer the question, we have to go back to the historic Northwest. Now, that's the territory that now covers Alberta, Saskatchewan, Manitoba, parts of Ontario, parts of British Columbia, and parts of the northern United States. And it was in the historic Northwest during the fur trade era that children of unions between First Nation and Europeans began to intermarry, and in that process began to develop a unique culture, language, and way of life. And so importantly in that process, they developed a political consciousness as a distinct people, or what we called then La Nouvelle Nation. And so it's this new nation, the Métis Nation, that I'm referring to in this presentation. Now, of course, the Métis Nation today looks a lot different than it did in the historic Northwest. The days of Gabriel Dumont and Louis Riel are not the reality of today. People that are members of the Métis Nation today are spread across borders, live all over Canada. But I think it's important to remember that they trace their ancestry to the historic Northwest through those kinship connections that they've developed. But today, the Métis Nation is represented by the 5 Métis governments that you see listed on this slide. And so in my research, I've traced the continuity between the historical forms of political organization in the time of the fur trade to these 5 Métis governments. And so I think for the purposes of the presentation, I think we have to remember that these are the 5 governments, and this is the Métis Nation to which I'm referring to. Now, of course, there are other organizations that represent the Métis, and a lot of them have come to play a significant role in Canada-Métis relations. But as the ministerial special representative on reconciliation with the Métis reminded us in his 2016 report, it's the 5 Métis governments that we outline here that have the legal authority to represent their community's interests, and in particular their Section 35 rights. So this fact has been acknowledged by lower courts as well as the Supreme Court. And so I'm going to focus on those governments. I'm happy to take questions for those of you who are interested on the role of organizations that represent the Métis interest. But I want to be clear that this talk is about the Métis Nation, because it's with the Métis Nation that the federal government has really begun to develop a new policy relationship. So what does that relationship look like? Moving on to the next slide, I'm going to highlight a couple of key developments. The first and most significant is the Métis Nation Accord. Some of you may remember the coverage of a Crown Métis Summit in Ottawa in April, and we had at a table Métis leaders sitting across from federal leaders, the Prime Minister and ministers, and they signed this accord. And in the accord, they outline the ways in which the Government of Canada and the Métis Nation are going to work together on set priorities and develop joint policy. But they identified some key priorities like employment and training, early learning and childcare, poverty reduction, and health and wellness. One of the important aspects of the Métis Nation Accord was that it set up a process, or what we call the bilateral mechanism. And this bilateral mechanism is a process through which they've committed to move forward on the relationship. And so it's through that process that they've begun to establish tables on Section 35 rights, and that they have a dialogue between their policy makers and political leaders. So the federal government, in addition to the Métis Nation Accord, has begun to sign memorandum of understanding with each of the Métis governments. And some of those memorandums have led to agreements. So in Ontario, we have a trilateral agreement in which the province participated. And in Alberta and Manitoba, we have a bilateral agreement between the Métis Nation government and the federal government. Now, why should we care about these key developments? And without being overly optimistic, I think it's important to note that the political landscape is changing. Some of you who have worked on First Nation and Inuit files will think, well, the federal government has repeatedly made policy commitments and sat with Indigenous leaders and made announcements. But the truth is, not really with the Métis. In fact, since Confederation, the federal government has largely been reluctant to sit down with the Métis. And this comes down to this, something I'll come back to in the presentation, this fear of them being responsible for the Métis. But it wasn't really until the last few years that we've seen policy dialogue between the Métis Nation and Canada. We could, of course, admit that in the 1980s, in the context of the constitutional debates, there was some discussion, but there was never any agreement on land or political rights that was reached. Probably the last agreement that they've had on land and political rights can be traced to 1869, which was when Louis Riel's provisional government sat down and negotiated the Manitoba Act with Canada. So this is something that is new. So the importance of the Métis Nation Accord and some of these key developments is I think that we've seen not only a commitment to develop a nation-to-nation relationship, but processes, mechanisms in place to actually move forward with that relationship. So I think it's important to acknowledge that this is a shift. So why is this shift happening? What has made it possible for this shift to occur? Well, there's a number of factors, and if we move on to the next slide, you'll see the ones that I'm going to focus on. Now, we could talk about a lot of other things that have changed over the years, but I'll focus on two elements of our constitutional order that not only help us explain how we got here, but help us understand whether or not change. So I'm going to also focus on how this constitutional order has changed in the wake of the Supreme Court of Canada's Daniels decision, which I'm sure many of you are interested in talking about, which we can pick up in more detail in the discussion. So what I want to argue today, or at least leave with you today, is that there's this unique policy environment in Canada that results from a potential discord between two elements of our constitutional order. And the first element is Section 91(24) of the Constitution Act of 1867, and the second one is Section 35 of the Constitution Act of 1982. So I'll address each of those components in turn so we can better understand how it is that we got to where we are. So if you move on to the next slide, the first element of the constitutional order is Section 91(24) of the Constitution Act. Now, at the time of Confederation, the Founding Fathers divided all the powers between the provincial and federal government. So in Section 91, we have all of those things that the federal government exercises jurisdiction over. And in Section 92, all of those things that provincial governments exercise jurisdiction over. And in Section 91, there's an Article 24, which reads, Indians and lands reserved for Indians. Now, historically, the federal government has always maintained that the Métis don't fall within that category. They're not Indians, or they don't have lands reserved for Indians. That doesn't apply to the Métis. By contrast, First Nations and the Inuit, they are considered Indian for the purposes of jurisdiction. So it wasn't until Daniels that this changed. And so in 2016, in Daniels, the court confirmed that the Métis fall within this understanding of Indians within the language of Section 91(24), and therefore fall under federal jurisdiction. But Daniel was about more than just providing clarity on who is Indian. In fact, one of the core grievances advanced by non-status Indians and the Métis in the process of this case was that uncertainty about their constitutional standing had led to what they called a legislative vacuum. There was no policy about the Métis because no one would sit down with them, and no one would assume constitutional jurisdiction over the Métis. So by clarifying who is Indians for the purposes of Section 91(24), the court also clarified to whom the Métis should turn to for policy redress, and the answer was the federal government. So the implication is that the federal government is the level of government that is responsible to, that can be responsible or is responsible if they choose to avail themselves of that responsibility to adopt legislation that affects the Métis. So that's the first element. The second element of the constitutional order is from 1982. And Section 35 of the Constitution Act of 1982 recognizes that existing Aboriginal and treaty rights of First Nations, Inuit, and Métis are recognized. Now, when our political leaders came up with that language, they didn't give us much detail, so we were left to figure out what that really meant. And so we turned to the courts. And since then, the Supreme Court has made clear that the grand purpose of Section 35 is the reconciliation of Aboriginal and non-Aboriginal Canadians in a mutually respectful long-term relationship. So what does reconciliation mean in this context? Well, the court has made that clear. They've said that the reconciliation requires that the federal government protect Aboriginal people's interests, and justify any infringements upon Aboriginal rights through federal regulation. So Canada has a federal duty to act in a fiduciary relationship with respect to Aboriginal peoples. Now, I think that's an important point to keep in mind, because the court made clear that the exclusive federal power that the government has to legislate over Indians has to be reconciled with their Section 35 duty to act in a fiduciary relationship with Indigenous peoples. And so that's the second element of our constitutional order. Now, some of you might say, well, I've looked at the text of the Constitution, and so why is this so different? In fact, one of the arguments that I try to show in the policy paper that you can read is that we now have a better understanding of what that constitutional order means, because we have decisions like the Daniels decisions and other decisions that have helped us to better understand what reconciliation means. And so if we move on to the next slide, the constitutional order that I'm describing gives rise to two different policy approaches. On the one hand, the federal government can make decisions and adopt legislation that affects the Métis. And so they have that authority under the Constitution Act of 1867. I'm not talking about a moral authority, I'm talking about the constitutional authority. And so that is what I call permissive. They can adopt legislation. On the other hand, the federal government must act in a fiduciary relationship with the Métis, and that's purposive. There's an obligation on the federal government to respect the interests and the rights of the Métis. So both of these constitutional provisions give rise to different ways in which we adopt policy. And in many ways, they're different policy foundations for policy development. So the question then is, what is Canada's approach? How does it fit within this constitutional order that I'm laying out? So if we go to the next slide, I show that, in fact, there's a little bit of both. Canada's approach, on the one hand, is a bit purposive and a bit permissive. At the level of discourse, the federal government has made clear that they want to move towards Section 35 rights. Prime Minister Trudeau has committed to work in a nation-to-nation relationship with the Métis and to advance reconciliation. And the creation of the Ministry of Crown Indigenous Relations and Northern Affairs is an example of this, where the objective is for Métis leaders to sit directly alongside federal leaders in a nation-to-nation relationship to move forward on rights. But when we look beyond the discourse, we see that that 1867 historical approach, where the federal government can decide what to do with respect to the Métis, is still knocking on the door. So when we have this top-down policy approach that continues to inform some of the policy decisions. Now, in the IRPP piece that you can read online, I talk about the 2017 budget. And I mentioned the program or the announcements that they made about housing. And the federal government had announced a big infusion of money and investment in housing, but it wasn't clear whether the Métis specifically were going to be involved in the spending, in the design, in the access. And in fact, it wasn't until the president of the Métis Nation, Clément Chartier, raised the issue that the Prime Minister acknowledged that the Métis hadn't been considered in the 2017 budget. And he also committed to include the Métis in the 2018 budget and in housing developments. So today, as we wait for the announcement of our federal minister on the 2018 budget, I encourage you all to look closely to see, well, what place is there for the Métis, and what does their housing, potentially housing announcements, as we have heard, might be in the budget, or even in other announcements. How do they specifically affect the Métis, and are the needs and interests and rights of the Métis taken into consideration? So I think at the level of discourse and high politics, we see that Canada has tried to move forward on a purposive, rights-based approach. But on the other side, there's still a top-down decision-making where the federal government can make decisions about the Métis, and both of those approaches are consistent with our constitutional order. Looking at that landscape, then I asked myself, well, should we be optimistic about how the federal government is interpreting its constitutional obligations and how it's moving forward with this relationship? So if we move to the last slide, and I'll conclude on this question of whether or not we should be optimistic. We see on the one hand that the creation of the Ministry of Crown and Indigenous Relations sends a signal that Canada is taking the reconciliation and the nation-to-nation relationship seriously. And in many ways, the ministerial restructuring is consistent with the constitutional framework that we have in place. On the one hand, the Ministry of Indigenous Services, it falls within the Section 9124 responsibility of the federal government to adopt programs and policies that affect the Métis. On the other hand, Ministry of Crown Indigenous Relations and Northern Affairs corresponds to the federal government's Section 35 duty to act in a fiduciary relationship with First Nations, Inuit, and Métis. So in a sense, the bureaucratic development that we've seen taps into the respective elements of Canada's constitutional order. So what's the problem? Well, the problem is it does very little to reconcile them. And if we remember, the court made very clear that the objective of Section 35 rights, or of Section 35 is reconciliation. And so the objective is to reconcile the duty to act in a fiduciary relationship with the legislative authority to act to adopt legislation. Don't only matter when we're talking about high-level politics. They matter in everyday policy. What would reconciliation look like if we took into account, if we reconciled these two elements of the constitutional order? Well, for starters, it would look like a partnership that extends across policy sectors. Because the goal isn't only to develop policies that protect the interests of the Métis, but that the Métis become partners in policy making. So in many ways, reconciliation isn't only concerned about what kind of policies are adopted, but how they're adopted. So as I conclude in the policy piece that I invite you all to read, beyond policy redress and bureaucratic restructuring, reconciliation requires a fundamental shift in attitude, and above all, the creation of a policy environment that respects Indigenous governments as partners in decision-making. So I'll leave it there for now, and hope that we can dig into some of the questions in the discussion period.
Thank you very much, Janique. That was a really clear and concise overview of your paper. We have questions coming in. Here's one. This one could take you right till 2 o'clock, but I'll leave it to you to scope it down into a narrower question. What are the problems in implementing a nation-to-nation relationship between the Métis and the federal government?
It's a good question, and indeed we could talk about it for a long time. But I think the starting point is to remember that this is new. And so there isn't necessarily the trust, the mechanisms, the history, the experience in place to move forward on that relationship. So what we've seen in the last couple of years is there's a lot of goodwill on the parts of both parties to move forward. But we don't have that institutional memory. We don't have that basis on which to rely historically upon. And so it requires both parties to build new things. And as much as we want to have an end result, to know what that relationship looks like and to have a nation-to-nation relationship, it also takes time. It requires building confidence, having procedures in place. And so I think the bilateral mechanism is a good first step in the sense that it's something it's called the permanent bilateral mechanism. If it's I don't know why permanent was necessary in the language, but it's intended to be there to stay so that they have those procedures in place to say, okay, we want to have a nation-to-nation relationship. How do we actually implement it? So the challenges, I think, before looking at what it'll look like is, well, how do we even get there? And that process of getting there is a challenge and is something that both parties have to develop.
Yes, there's in a way a need to develop a parallel with the intergovernmental relations that exist between the federal and provincial and territorial governments. I worked in this area in the Privy Council office for a number of years, and people had a history of working with their counterparts in other governments, and knowing them personally, sharing expertise, sharing experience was very important in addressing some of the current issues. And as Janique pointed out, developing these relationships, which after all are interpersonal, will take time. Okay.
And there has been some work on that. Over the years, I think it's really at the level of behind the scenes that we have seen some of those developments. But a lot of that has been behind the scenes, and now we're seeing it's in the forefront. What does it look like when we have a more comprehensive approach?
Yes, okay. We have another question here. When we talk about reconciliation with First Nations, usually it means dealing with colonial history, residential schools, and so on. What does reconciliation mean in the context of the Métis?
Well, first, I think it means similar things in some ways to the examples that you've mentioned. Many Métis have participated in the residential school system and were victims of the colonial policies that Canada's had in place. So it involves that larger process of reconciliation. But if we look at it from a legal perspective, for the Métis, it's part of the answer to the reconciliation is being part of the conversation and being partners in that conversation. So I think it's up to Métis leaders to determine what they want reconciliation to look like alongside Canada in that conversation. But being part of that is, I think, the first step, because historically the Métis were sidelined in those conversations. And so we neglected to mention their role, for example, in the residential school system. We neglected to talk about how much they're affected by the colonial policies that Canada's had in place. So they need to be part of that conversation, but also a conversation that addresses the specific needs of the Métis. And I think to know what those needs are, that conversation needs to take place between political leaders, but also at the level of communities.
Okay, another person has really sent in two questions. I'm going to put them to you together, Janique. I think it's fair. They are linked. Are the Métis rights under the Daniels decision comparable to the rights of First Nations? For example, band membership, taxes, education funding? And can the Métis negotiate modern treaties with the federal government for a land base?
Great questions. Well, the first thing that I want to clarify is that Daniels wasn't about rights. Daniels had really nothing to say about Métis rights or the rights of non-status Indians, as was defined in that language in the proceedings. Instead, it had to do with jurisdiction. So where Section 35 of 1982 is about rights, Section 9124 is about jurisdiction. And essentially, it just means, well, who is responsible? And really the responsibility is again permissive. So the federal government can adopt policies that relate to the Métis. So Daniels doesn't give rights to the Métis and doesn't create anything new. In fact, it just provides us clarity. But the clarity is important because now the Métis know to whom they can turn, and the federal government can no longer say, well, I don't have a role to be at that table. I don't have to be at the table. In fact, the federal government, if it so chooses, is the one who should be at the table. So there's no new rights, and it doesn't mean, and so it doesn't create anything. Now, the federal government could develop legislation that creates certain provisions, programs, and rights. Now, that is within their authority under Section 9124, and that's where we're waiting to see what's going to happen. Is the federal government going to adopt a legislative framework? Now, if they're doing it within a context of reconciliation, that framework would respect and would be developed alongside the Métis. That would be the implications or the intentions in the interpretation that I've given of the constitutional framework. But the federal government wouldn't just adopt a legislative piece like the Union Act. Instead, there would be some legislative framework, for example, that recognized Métis self-government, that allowed them to move forward on rights. That sort of that's what's been discussed. Now, in terms of the second question, well, then can the Métis negotiate land claims? Well, they can't negotiate land claims under the current political framework in place. And by that, I mean the Métis don't have access, or at least the Métis Nation doesn't have access to the specific land claims agreements process that's currently in place. And so there was a ministerial report in 2015, I think, on the land claims process that pointed that out, that said, listen, the Métis aren't nowhere in that process because that process is designed for First Nations treaty rights and in modern land claims in which the Inuit participate. So within the process that exists, no, I don't think that would be, I don't think there's room. But that doesn't mean that they can't negotiate modern land claims under a different process. And I think that's what we're seeing develop in the wake of the Manitoba Métis Federation decision, which was a Supreme Court decision in 2013 that acknowledged that Canada has not acted honorably with respect to land rights for the Métis community in Manitoba. So we've seen some discussions move forward on that front. And so that's not a land claim negotiation just yet, but those are the kinds of conversations that lead to land claims negotiations should there be a different political process put in place. So not on the existing process, but there is political space for them to negotiate if there are willing partners.
Okay. This one may be a little bit more challenging, but I'll put it to you. There is an emerging reconciliatory policy arrangement, policy relationship with the Métis, and what can we learn from that process with regard to reconciliation with non-Métis Indigenous peoples?
So the question, as I understand the question, is what do the developments happening with the Métis, how can they help us to lead to reconciliation beyond Indigenous peoples?
No, beyond the Métis.
Oh, beyond the Métis.
The other Indigenous people.
Oh, to other Indigenous peoples. Sorry, thank you for that clarification. That's a good question. Probably something that others will have as much of an insight into as me. I think that one of the advantages is not the right word, but one of the characteristics of Canada-Métis relations is that we're dealing with a relatively cohesive group. So the Métis Nation is composed of 5 governments. And those 5 governments, of course, have their own decision-making power, but work together under an umbrella. And there's less division of sovereignty than there is, for example, in some other Indigenous groups, for example, with First Nations, which is a far more diverse, different governance structures and different ways of exercising sovereignty within their collective governing bodies. So I think with the Métis, we have a bit of a smaller scale situation where they're negotiating more directly with the federal government with a smaller group. And that's not necessarily something to be reproduced, but something that we can learn from, that we might have some lessons about how that relationship might be more scalable or might not as well transfer well to other groups. I think it's still too early to tell whether there's a model or something to reproduce. I think really right now it's seeing where it goes and learning from that to see whether we can apply anything to other communities and beyond Indigenous communities as well.
We've got a question now on an issue that I wanted to raise, but I don't have to because we've got a good question here. Through bilateral and trilateral agreements, several First Nations run organizations have been developed in a few provinces to manage programs for First Nations people. For example, the First Nations Health Authority in BC. Now that the political landscape for the Métis is changing, are we seeing any similar developments for Métis nations?
It's a great question. And recently in the fall, there was a meeting in Ottawa with a lot of the childcare and family services providers that are already doing some of that work. Now, that's one of the areas in which the Métis governments have already stepped in and played a big role. And through agreements, we could see that that might change, and that might become a little bit more elaborate as well. So the examples that we saw in the creation of the First Nations authorities in BC, for example, I don't know whether that we would say that there's a model to reproduce, but or to replicate, but there certainly is an interest in those areas that have been identified by Métis governments, such as Child and Family Services, to have collaborative programs and to work directly with federal government with federal government transfers to be able to deliver specific services that are tailored to the Métis. Now, it's not only in Métis Child and Family Services. Métis governments have expressed also an interest in working in other fields, including environmental protection. So we might see some bilateral and trilateral agreements as well in those areas, and see Métis governments develop capacity in more areas.
Here's another question. This is another one that could probably keep us going close to 2 o'clock. Do you see difficulties in defining who is Métis? Some court rulings have been quite permissive, while the Métis Nation under the Métis National Council is conceived in a more specific way. With whom is the nation-to-nation relationship? Only the Métis National Council members, or other Métis, as some people have defined themselves?
That's a good question, and I think the answer is one that not everybody agrees on, but I think that there is a very clear consensus on who the Métis are. Now, the Métis Nation's definition of who is a Métis is also most of the characteristics that they have in their definition of the Métis National Council have been taken up by the Supreme Court, or were reiterated in the Supreme Court in the Pali decision. And those criteria include being able to self-identify, but trace your ancestry, and also be accepted by the Métis community. And I think those criteria have been consistent throughout. Now, I think now we have a very clear understanding that it is the Métis Nation with which the federal government is developing a relationship and has an obligation to develop a relationship for Section 35 rights. And I think in this, the special ministerial representative on reconciliation with the Métis, Tom Isaac, he released a report in 2016 that made that very clear. While there are other organizations, and there are certainly other groups that have mixed Indigenous ancestry, for the purposes of Métis Section 35 rights, it is the Métis Nation with which the federal government has to negotiate and to work with. So I don't think that there's any confusion about that at the level of the governments or at the level of the courts. I think it becomes more difficult to say, well, what happens to other groups that aren't part of the Métis Nation, but that are of mixed Indigenous ancestry? And that question, and what rights do they have? What is the relationship with the federal government? Those are questions that are still less clear.
Thank you. We have another participant who sent in a group of questions. In this case, I'm going to divide them because a couple of them are quite different from the others. So I'll start with this. Are there treaties with Métis nations? And if not, what is the overall architecture of the Métis relationship with the Crown?
So the treaty relations with the Métis, so a lot of people speak about, and Louis Riel spoke about, the Manitoba Act as a treaty. So the negotiation of the provisional government in Manitoba in 1869, when Canada was trying to move westward in protecting rights, linguistic, religious, cultural rights that were included in the Manitoba Act, that was viewed by many Métis leaders as a treaty, so a treaty-based relationship. Of course, some Métis communities also joined treaties and signed treaties with First Nations, and we saw that as adhesions to treaties were on or occurred. So, but the basis of the relationship has primarily been a political relationship, this treaty-like relationship. So we don't talk necessarily in Métis politics about the numbered treaties, right? Those aren't the basis of the relationship. It's the political relationship. But that notion of whether or not they're informed by treaties, absolutely. That treaties recognize the sovereignty of both parties and also impose obligations moving forward. And so that notion of treaty-based relationships, I think, applies across, applies as well to the Métis. But I say that cautioning that that's not always the language that's used, and I wouldn't want to mislead listeners to think that the treaties are the ones that were necessarily negotiated with the Métis. So there's different. Historically, when we talk about treaties, there are different categories of treaties, and the Métis work in a treaty-like relationship with the federal government. Was there a second part to that question about treaties?
No, the participants sent another question, which I'll now land your way. What are the primary outcomes that you think Métis nations are hoping will come out of reconciliation efforts and nation-to-nation talks with the federal government? Is it a matter of land claims, righting historical wrongs, or other material issues?
Well, besides what I would like to see, I think that the Métis leaders have made very clear that they have sets of priorities, and one of them is land. One of them is justice, and another one is sort of building for the future. So in recent years, we've seen some speeches and announcements and discourse around these issues, particularly in Manitoba. The president of the Manitoba Métis Federation has made very clear that he wants to move forward on the Manitoba Métis Federation decision of the Supreme Court and right the wrongs of past to which the Métis were entitled, that there's some reparation or there's some movement on that. So is that part of reconciliation? I think it's a piece of the puzzle. I don't think it's the whole puzzle. I think one of the big parts of righting the wrongs is to look at rights. We don't really have a comprehensive set of Métis recognized rights. The federal government doesn't have policy on what rights the Métis have, and they're excluded from many of the policies that address the rights of First Nations and Inuits. So at some level, there's this gap there that we're waiting to fill. And I think that's why the tables, the dialogue that are happening through the Section 35 tables set up through the bilateral mechanism, I think those are really important in setting out what that will look like. And so I think that's part of reconciliation, moving forward on rights. That addresses part of the historical wrongs, but also moving forward. What's the place of the Métis? What does the relationship look like with Canada, and what kind of day-to-day rights do they have access to? I think that will unfold in those conversations that have begun under the bilateral mechanism.
Thank you. We have a question here, I assume, from somebody in Quebec. Do Quebec municipalities have the authority to respond to Métis claims? If not, do the Métis have recourse to the federal government?
It seems that the question is probably inspired by a particular circumstance, and so I'm not sure what the context is, but I think we have to be careful about talking about or using the language of rights when we say, well, do the municipalities have a right to, or do Métis have a right in that context? The federal government has a responsibility towards the Métis, and the provincial governments do as well, and by extension, as creatures of the provincial government, municipal governments have some responsibilities. We could make that argument, but the authority that's responsible for implementing rights under the jurisdictional landscape that has been laid out to date is the federal government. So that, without knowing more about the context, it's difficult for me to comment on the specific issue at hand. But the Métis Nation negotiates their rights with Canada. In terms of specific communities, they work through their governance bodies generally to advance their rights. Now, that there are, of course, day-to-day challenges that arise, and I'm not sure what the specific context of this person has in mind, but probably that context is something that that needs to be looked at on a case-by-case basis to see, well, what is the nature of the claim being put forward, and what's really at issue. Certainly, if it's a rights-based issue, well, then we have to determine whether the community has that right, because under our current constitutional framework or jurisdictional interpretation of the framework, we have to prove the existence of a Métis community for the exercise of Section 35 rights. So that's a bit of a can of worms, a more complicated question. But again, that's part of the interpretation of the jurisdictional landscape.
We have another question that links to this. Maybe it's come from the same person. It's in some sense a bit of a repetition, but I'm going to put it anyway. Do you see any recognition of rights for the Métis in Quebec? For example, the city of Gatineau in Quebec claims there are no Métis in the province. Yet on the opposite shore in Ottawa, there are Métis recognized. Will they have recourse to appeal to the federal government to protect their rights? I'm not sure whether the person means any Métis that might be in Quebec, because the view of the city of Gatineau might not be shared by everyone. But I'll let you try to respond. Perhaps start, if you will, Janique, with the question of Métis within Quebec, bearing in mind that of the 5 organizations that you had in your presentation, there isn't a Quebec-based one. Where do the Quebec Métis, because there are some, or at least as far as identification, where do they fit in the picture?
Right. So this is a bit of a delicate question in the sense that there hasn't been in the courts the finding of a Métis community in Quebec. Now, when I began the presentation, I spoke about the historic Northwest, and that historic Northwest is the territory on which the Métis Nation was formed. Now, that's the territory on which the kinship connections were developed and through which the Métis Nation emerged. Now that is very clear in the research that the Métis Nation emerged in the historic Northwest. That doesn't mean that everybody now lives in Manitoba and Saskatchewan, Alberta. There are Métis who are part of the Métis Nation who live in other places. And in fact, if you live in Quebec and trace your ancestry to the Red River, for example, you can apply to be a citizen of the Métis Nation of the Manitoba Métis Federation. So, and it's the 5 Métis governments that assess applications for membership in the Métis Nation through a registrar. So, no matter where a person lives, if they trace their ancestry back to the Métis Nation, then they are connected. Now, it becomes less clear as to, can you exercise your rights anywhere? The court has been clear that they impose a recognition of the community. So you have to prove the existence of a community in order to exercise, for example, fishing and hunting rights in that community. That's what Pauli in 2003 was about. And so in those communities that can establish that they have Métis rights, then that's not a problem. We haven't seen any successful challenges outside or in Quebec that have proved the existence of Métis rights. So what happens to people who self-identify as Métis? Well, if they're part of the Métis Nation and they are connected to the Métis Nation, well, they can be linked to the Métis Nation. But again, the exercise of rights, until we have a different interpretation of the courts, require the finding of a Métis community. So I think that's the best way that I can sort of point to this tension, is that self-identity isn't the only criteria. To be a member of the Métis Nation, one has to prove the existence of the historic Métis community. So we have to know what those communities are. They also have to be accepted by the Métis Nation. So that's when I said there's a registrar and a process in place that Métis governments use. Well, those people have to go through that process in order to be a member of the Métis Nation. And so that's one aspect of the process. But on the other hand, we also have the exercise of Métis rights, where under our current jurisdictional framework, communities have to prove the existence of rights. That might change if we have a political framework on Section 35 rights, which doesn't exist right now. Right now, we only have a legal framework. But even if we have that political framework, insofar as it's negotiated with the 5 Métis governments that represent the Métis Nation, I would expect that it would apply to citizens of those governments. So there would have to be a link between the self-identity and those citizens.
I have what isn't really a question, but I'm going to read it out because it'll be of benefit to probably everyone. The person has written the following: there's a rights-bearing community in the Mattawa area. I'm guessing the Quebec question has to do with this community possibly having rights, for example, harvesting in Quebec as well as in Ontario. I think Mattawa is not too far from Ottawa, but I may be wrong on that, Janique.
Again, the communities that have been, the communities that have been identified through the courts are listed, right? So beyond what communities state, I can't really comment on that until there's a proven existence of a community. It's hard for me to comment on it. Within Ontario, the Métis Nation of Ontario has on its website listed some of the communities that they recognize. That's not necessarily what the courts have recognized yet, but people who want to find out more can go and read more about the Ontario Métis communities there.
Thank you. I've got a question here. This is another quite broad one. The issue with the Kinder Morgan pipeline seems to demonstrate that the federal government considers reconciliation a priority only insofar as it is convenient and does not challenge political and economic goals. How might this context impact the emerging relationship between the Métis and the state?
That's an excellent question. I think there's always a juggling of priorities, but the truth or the fact of the matter is Métis rights are always there and Indigenous rights exist in law. That doesn't necessarily mean that the political will to implement the rights is always there, but I think that to remember that they exist they have constitutional standing is important because they can continue to rely on that in affirming rights. Now, what do we do about political context? Well, in some ways, the Métis Nation Accord and the discussions that have happened that led to the Métis Nation Accord were in large part the result of the Métis and the federal government finding common ground. And they found common ground on economic objectives and on social and political objectives. So I think that's a lesson or a reminder of how powerful that can be in leading to political will and agreements. So the Métis have, always been willing to engage on economic issues with the federal government. That doesn't mean that they always have the same objectives, but we've seen discussions there in the past. So, of course, that doesn't. I don't want to suggest that that means that they'll always have an open ear and be able to overcome circumstances. But I think that the strength of that relationship is a factor moving forward. So we'll have to wait and see how the federal government juggles priorities. There's always going to be different objectives in play, but if reconciliation and rights continues to be at the top of the agenda, which is what the discourse is suggesting, hopefully actions will follow.
I'm going to put one final, also fairly broad question just to conclude. Seems to me from watching not only political developments, but the research and so on, that there's a greater sensitization towards Indigenous issues across the country. We're seeing universities changing their faculties, establishing new schools, hiring a much larger number of Indigenous instructors. We're seeing greater interest within certain provincial governments, the city level, and so on. Within all that, first of all, do you agree with me? But within all that, how optimistic are you that the Métis dimension will receive sufficient attention? The First Nations have a much more structured relationship. There's more jurisprudence. They're more numerous, and so on. Is there a challenge just in the sense of this all being so very large and often quite focused on the First Nations dimension?
That's an excellent question. I agree that the Indigenous issues are in the limelight, that we're finally talking about the role and the place and the responsibilities of institutions and of Indigenous peoples within those institutions, whether it be in academia, government, and other aspects of society. So that's certainly an exciting development. With respect to whether or not we should be optimistic about the place of the Métis in those conversations, I think that one of the reasons I agreed to do this seminar or this webinar, I should say, is that there's a lot of misconception and confusion, or there seems to be a lot of confusion. People say, well, we don't know who the Métis are. We don't, who are we really talking to? Who are the governments? And I think that popular discourse, or maybe that notion, when we look at what's actually happening, that's not the case. It's very clear within on the ground. Who is the federal government talking to? The 5 Métis governments. What do they look like? How do they work? All of those things are established. And so one of the objectives that I had is to talk about it so we can better understand, well, who are these people? How are they working? What are their priorities? And what is the relationship with the federal government? And I think the more that we understand the Métis Nation, the easier it will be to include them in those developments and ensure that they're part of the conversation. I think there's a danger in relying on that confusion to exclude, and that's one of the arguments that's been made in scholarship, is that confusion over the Métis has essentially allowed some people to discard them. So I think it's upon all of us to learn more about the Métis Nation and their rights and what their claims are, so that we can better include them as we move forward on reconciliation, that we understand the impact that colonial policies have had on them, but also where they're trying to move forward and where they're trying to go in the future. So I think that part of the answer to the question of will they be included is, well, how much do we know, and do we know enough to be able to have intelligent conversations and include them in a way that's appropriate and respectful and takes into account the reality of the Métis specifically. So I think the more that people who are listening in on this webinar show interest, the more hopeful I am that they will be included.
Thank you. Interest is indeed very important, and so is information. It's one of the basic functions of research. We always hope, of course, that it's pushed a bit further through public debate and impact on policymaking. We would not have been doing this webinar 2 years ago. We're doing it today, and Janique has done a huge service through her paper and also through the webinar by sharing the information and evaluation that she is so knowledgeable about. So thanks very much, Janique, and thank you everyone for your questions. Unfortunately, we didn't get to quite all of them. We've run out of time, but we really appreciate your interest in IRPP. And the video, you can let other people know, the video of this webinar will be on YouTube within the next half hour or so, and you can access that through the IRPP website if you click on events, or I assume through the search function of YouTube. So thanks again, and goodbye from Montreal.